Karsak for the insightful session, and I hope everyone has enjoyed this session. Ladies and gentlemen, we are now heading towards the closing session of this day long symposium. I feel privileged to invite the chief guest of today's event, His Lordship, Honorable Mr. Justice Miyagul Hassan Aurangzeb, a judge of Supreme Court of Pakistan and advisor of the Board of Governors of the Federal Judiciary Academy. Justice Aurangzeb is widely respected for his insightful jurisprudence and unwavering commitment to upholding justice and the rule of law. We are truly privileged to have him with us today to deliver this closing address. I can feel that everyone is anxiously waiting to hear some distilled wisdom and some crisp takeaways. Ladies and gentlemen, I would request for standing ovation for the chief guest. Over to you, Lordship. Sir, please.
Assalamu alaikum. Thank you very much, Ji, for that introduction. Um, I'm privileged to be once again here at the Federal Judicial Academy. My association with this academy goes back to 2005, when I started lecturing here on the law of arbitration. But we will come directly to the subject at hand, which has fixated not just all of us here in Pakistan, but the entire world. Artificial intelligence in the realm of law, particularly with reference to adjudication. Should we rely on it? Should we use it? Should we cut and paste? Should the chair of the judge be replaced with a computer? And to what extent? There are varying thoughts over that. And when I say the rest of the world, I 2 weeks ago attended a conference in Malta, where there were chief justices and judges of the Supreme Court of different Commonwealth countries. And some of them outright rejected the idea of the use of artificial intelligence for an adjudicate. They said, no, there has to be an application of human mind, because it is the human mind and heart and eyes that will gauge the demeanor of a witness, will understand the case, will have human elements which are specific attributes and which do not exist in the worlds of computer, no matter how automated they become. But there were others, like me, who welcomed the idea of artificial intelligence. It is a step towards progression. I remember the time when we started our law practice, the research was done through the ALDs. It was extremely time consuming. From the time when the first publication came to the latest one. We would burn the midnight oil doing that. And I believe it was 20 or 21 years ago when Pakistan Law Site came, and we heaved a sigh of relief with that. But the Pakistan Law Site, even though it's by the PLD publications, leaves much to be desired as far as research is concerned. There are terrible mistakes in the text. So I will never cut and paste a certain portion or a paragraph in my judgment. I will have to have it proofread with the actual book. So this is a word of caution that we ought to bear in mind. There was a mention of headnotes. It is extremely dangerous. I would endorse the earlier speaker's views. It's extremely dangerous to rely on headnotes. They're not the judgment. And I would request all the judges over here that when they have to reproduce a portion of the judgment, please do not reproduce the headnote. It's a practice that actually needs to be deprecated. And we, through our member inspection team, have informed all the judges of the district judiciary, at least in Islamabad, with a word of caution not to use the head notes, but to use the actual text. Another question was asked as to what happens that if there is a detailed judgment of the High Court and that judgment is a reported judgment. And because it is now in the public domain, it is left to be cited. But through a judgment of the Supreme Court, which is not reported, and which could be a judgment with consent, for instance, that judgment is set aside. Does that reported judgment continue to be used as a precedent? Well, the answer to that is obviously not. But how does one know? You will now know that by going to the Supreme Court site, because it will tell you which of the judgments of the High Courts have been upheld or not. Obviously, lawyers for this purpose have to be a little more cautious. And more than lawyers, it is the judges who have to be cautious because it is their judgment which will stand. So reliance on a reported judgment, which has been set aside by an unreported order or a judgment of the Supreme Court, will lead to a miscarriage of justice. So you have to be computer savvy, you have to be able to go onto the Supreme Court website to see as to whether the reported judgment, which will have details of whether it's a civil revision, whether it's a writ petition, whether it's an appeal and their numbers, whether it is upheld or not. Now, what is the extent to which you can use artificial intelligence or technology in writing your judgments or carrying out research? Research, there is no prohibition, and the world is your boundary. You can use any law site for that. But incorporating any of the text in your judgment is a different matter. It's a serious matter. The judgment has your signature, which means that you are its author. It is your judgment. There is no harm if what you gather from artificial intelligence meets your mind, that this is indeed what I wanted to say in my judgment, by all means incorporate it. It will be perfect grammar. But most definitely do not replace your thinking mind with what the computer tells you. I'll give you an example. If you take a book of All England Law Reports or any of the English law reports, towards the end of the judgment, you will find mention of the fact that judgment as proposed by, and then there's a lawyer's name. That lawyer is one of the lawyers for the parties. So when the two contesting parties are arguing a case, when they close their arguments, they say, Your Honor, this is my proposed draft of the judgment. It's a fair judgment, but it's a judgment which shows that the case is decided in favor of the party that he represents. The other side also gives a proposed draft of the judgment. So the judge has two judgments before him. He may discard both of them. He may adopt one either in toto or partially, or use some areas of it. Same is the case with AI. AI will give you a text. It will give you a lot of material. You can discard it because it does not meet your mind. You can use a portion of it, or you can use it in toto. But as long as your mind does not abdicate the essential responsibility of adjudication, you ought to know what is written inside out. So for all of us who use the computer in our duties, some of us have it along with us when we are hearing a case. We open it, we open the law site, and we do a research right there just to contradict the lawyer that, no, sorry, sir, this judgment has been upheld. or this is the latest law, I would encourage all of you to do that. There is no harm that when you are hearing a case, your laptop is next to you. When writing a judgment, whether it is West law or now the East law, whether it is Indian Qanun, whether it is Manupatra or our Pakistan law side, these are all very welcome developments and are aids and should only be treated as aids in you rendering a judgment and nothing more than that. Thank you, sir.
Thank you, Your Lordship, for your profound and inspiring words. To formally close this symposia, I would like to invite Honorable State Minister for Law and Justice, Barrister Akhil Malik, to present vote of thanks. The Honorable Minister has spearheaded its efforts of the government for promoting transparency and technological advancement in our justice system. His dedication to ensure technological integration in judicial process speaks of itself. Ladies and gentlemen, Honorable State Minister, Barrister Akhil Malik.
Bismillah ar-Rahman ar-Rahim. Honorable Justice Miagal Aurangzeb Saab, distinguished panelists, respected guests, ladies and gentlemen, Assalamu alaikum. Being the host of the event, of course, at Ministry of Law and Justice, I'm here to deliver the vote of thanks to all the participants who have actually participated in this day-long annual symposium. So I actually won't be taking too long, but just a few points that I wanted to make. It is truly an honor and a privilege for me, as your Minister for State for Law and Justice and a fellow member of the legal fraternity, because prior to this role, very much, being in the field, practicing law, being a litigator, also having appeared before Lordship and other members of judiciary as well. So I do understand, because in an era when we actually, when I read law and my peers as well, I must state this, with this whole culture in Pakistan of when we came back, or perhaps in myself, when I came back, I saw this whole steno culture. And for me, to be honest with you and personally, I will certainly be going down to the points and going through the points that I'm supposed to make as well, but sharing a personal experience with you. We were trained, myself and my peers, we were trained to draft ourselves, to write the opinion on any of the legal matters ourselves. So of course, having trained in Pakistan and abroad as well, for us it was, for me personally, it was very difficult to sort of, go ahead with this entire steno system and dictating it to somebody else. Because I think the thought process, when it flows, when you write it yourself, when you draft it yourself, when you form an opinion, just like Lordship has quite rightly stated that AI cannot actually do away with the human element that's supposed to be there. The AI in your judgment cannot replace the due consideration that you have to give to those mitigating or extenuating circumstances. And it is imperative that you have to have that human element attached to it, not just to truly rely on artificial intelligence. So it's quite apt. But in going forward and delivering my vote of thanks to all the members who've attended here and all the participants. So this definitely has been one of the most important annual symposium for judges on the technology for justice. And I think in this day and age of great technological advancements that we've made, so we must use these new tools in the legal system of our country as well. As someone who's practiced law and has been involved in shaping the policy, I understand that the critical importance of technology in transforming the legal landscape. Seminars such as this empower the judiciary with the insight, tools, and shared learning that is necessary to face the new realities of justice in a digital world. The discussions help bridge the gap between emerging legal challenges and judicial preparedness, ensuring that our courts remain accessible, effective, and future-ready. I strongly believe that judges, as guardians of justice, must be at the heart of innovation in the legal system. Today's symposium reaffirmed that with the right application of technology, we can assure that justice becomes more transparent, responsive, and inclusive, while upholding the core principles of fairness and constitutional integrity. I extend my deepest gratitude to Honorable Mr. Justice Miangul Hassan Aurangzeb Saab, the Judge of the Supreme Court, for his inspiring and forward-looking address that reminded us that judiciary's evolving role in a digital age and how we can use these new tools within the sphere, within our sort of legal space, to better equip ourselves in rendering judgments or writing judgments. I also extend my gratitude to all the session contributors, from judiciary and ministry teams to experts from MOIT, UNODC, and beyond, for insights on justice reforms, virtual assets, witness protection, and the AI tools like Judge GPT. My heartfelt appreciation also goes to all the honorable judges, experts, speakers, and participants for their thoughtful contributions and active engagement throughout the day. Let us move forward with collective resolve to build a judicial system and a justice system that is digital in design, human in essence, and uncompromising in integrity. I thank you all for your time.
Thank you, Excellency, for your closing reflection and your support. Moving ahead, we have some souvenirs for our distinguished dignitaries. First of all, I would request the Honorable State Minister to present a souvenir on behalf of Ministry of Law and Justice to His Lordship, Mr. Justice Miangul Hassan Aurangzeb.